substitutes my phone. You have Wi-Fi.
You're gonna.
Yeah.
I'll just stay here.
Yeah. Awesome.
Let's move this a bit.
Check. Fine.
Theo.
Yeah.
Does anyone like to see them inside?
No.
Next to him.
They're coming, they're coming.
Or are they? Okay.
Yeah.
All right.
Okay, sprinting. When I know all the hero model world.
It takes out of basic to be ready with that. This is true. It is actually very similar to the world.
Okay, I think we're good to go.
I'm sorry.
I'm Jack, I'm the chair, I have no preference. Pronouns, sitting with me is Bill and Caitlin. Great, what we'll do is go around the room, if people want to give the order they're speaking in, preferred pronouns, and also if they consent to being streamed, because this is going to be shown to the world via the internet. Opening governments.
Anna speaking first, sure day is fine. I don't consent to streaming.
Valerio is speaking second. Sure.
Okay, hello.
Velina speaking first. Okay.
You consent to streaming.
Can I say it in the beginning of my speech because I am uncertain?
You can just switch it off if you want to. You can just switch off the video and mic from the Zoom.
Oh, with big streamed at back then.
Yeah.
Oh, that's okay.
So do we
It's
think there?
It's a
It's very delayed.
Doesn't matter, stop it. Thank you.
Alex second, no preference, consent.
PG.
Matt speaking first, consent.
Ahmed, second, no preference. Yeah.
MCO.
Naomi speaking first, I consent.
Harry speaking second, consent.
Great, speakers are 7 minutes in, the first and last minute is expected. Dylan, are you okay to time to obviously, it's the incentive of all speakers themselves, so that you know where you are in your speech. After 7:15, we will stop listening. Is everything okay?
I'm just curious where the camera is.
It's
It's there.
That is so cool. Okay, okay.
Okay, great. Without further ado, Prime Minister, the floor is yours.
Can I speak from there because I can't lean on this?
Yeah.
But here you are actually in the camera's view.
You can switch off the camera and
Yeah.
Here you are not visible. And it's only your paper is in the end.
Yeah, I'm here to will be good. Can't be seen there.
It's fine.
Can you speak with the like screen moving in front of you?
Cool.
No, I think you can speak from there and it's good, right?
I think we're every here. Yeah, I'm just gonna.
Yeah.
I think that when OO and likely CO as well is focusing mostly on stacked courts and how courts are bad, they're already only playing extreme versions of the motion. Thus, they are on a very short territory. I'm going to win that as well. But note, we characterize that it is especially important to talk about courts that are more balanced because that's where the debate makes most sense. Because otherwise, if they want to tell me that they have such a stacked court that they can decide whatever they want, and there is one party who has so much political power that they can stack the court repeatedly year after year, it means that they are very likely also able to change the constitution or do whatever else that they want. So that likely means that this isn't a reasonable case to play on. I'm going to win on it anyway. So first rebuttal, then reconstruction and weighing. Secondly, like a different argument that's going to be fun. Cool. So first thing that OO tells us is that constitutions are up to date because they've been made pretty recently. Firstly, that assumes that the Western, how do they call it, bloc that was created 40 to 50 years ago was actually doing a good job 40 to 50 years ago. I think that this is the first wrong assumption that OO makes because these are also the people that were killing leaders in Latin America because they just weren't into communism and they don't really like democracy that much. So when they tell us that they were better in the past, I think that we can use the fact that they are better now so they can influence the recreation of the rights now. Secondarily, they also tell us that they were created, these constitutions were created in a volatile time, and this is good for them because it means that the people would have rioted. Note, in a volatile time, the people are less interested with the political sphere and they're more interested with not getting shot and putting food on the table. That means that in these times, it is especially likely that the elites are the ones controlling the creation of the constitution and anything in the political sphere. Thus, they're more likely to not be that progressive or to not be that centered around the will of the people. So the first assumption that the constitution is good falls from OO. Second assumption is that change is bad and scary, and I get it. It's like we all think that change is bad and scary, but it seems like OO is okay with that change whenever they say that it can be repealed and then put back again every 10 years. Note that if they want to stand for that, it means that they stand for a very variable and malleable interpretation of the constitution, so then the delta doesn't really make sense on their side of the house. But moreover, the main point from OO is that the decision of the government are going to stay forever and the courts are bad because they're stacked politically. Note, first of all, I think that it is unlikely that these are all the scenarios that we're talking about, but even in those scenarios, when we're talking about the US or something like that, the legality of the change becomes more important for opposition than the morality of the change. This is crucial because it's easier for you to convince your electorate that what you're doing is right when you're talking in like law terms and when you're talking about the forefathers and the constitution than it is when you're talking about whether this is just currently. Because most people in the US are pro-abortion. They believe that it should exist, and yet it was repealed because it was easier to say, well, now that like the constitution says this, these legalistic arguments are more likely to persuade the people, thus it's more likely that opposition can repeal the fundamental rights of the population in these extreme cases that they want to talk about. Secondarily, they don't interact with our point about how the arguments in the court are constructed, because note, when you have to do like a far-fetched argument, when you have to tie some very specific right currently with a right that didn't exist 200 years ago, because for example, like right to privacy wasn't really a thing because you could just be within your own house 200 miles away from everyone else, it's very hard for you to make these stretches in argumentation. That means that it's easier for other people to take them down and for judges to not believe them. That's why it's significantly harder when you have a Bill of Rights to do anything with it. But when you're asking yourself whether this is the just and moral thing to do, that is when it becomes more intuitive for people, judges, and lawyers why this is the correct choice and why people deserve those rights that we're trying to implement. Before I move into the weight lecture.
So just to be clear, the premise of your case is that judges will routinely, not all the time, add new rights or subtract rights, in which case you do have a constitutional rights which change regularly. I like what CG want to claim.
So what we're arguing is that when it is necessary or when there needs to be like minor tweaks in how these rights are instated within society, it can be done on our side without firstly the legalistic hassle of and secondarily that your rights are better protected in a society where we're asking whether something is moral rather than we're asking whether something is in tune with what the forefathers thought of. Now, wait. I think that even if you are people, like, first of all, the cases that OO is talking about are quite minor in the large spectrum of the debate, right? It's likely just the US and maybe a few other states. But for most states, there are better mechanisms in place to ensure that the court isn't stacked, because some people are appointed by the president, some people are appointed by the parliament, or they have different systems to ensure that the court isn't stacked. Thus, it's more likely that they numerically have less cases. Secondarily, the way that you have to do here is that on our side of the house, it is easier for people to interact with the argumentation that the people in court are providing, which brings me to our largely second argument in this debate. I think that the precursor to everything in this debate is that people actually come up with these issues and they go to court with them, because likely what happens is that I feel as a citizen that my right has been infringed, and thus I go to court and I say that my right has been infringed. This is the precursor to all other things, because otherwise we can't have the debate. Firstly, because they are the ones that are creating the precedent. Secondly, because if they back down at any point, the precedent doesn't get to be created and the right doesn't get to get instated. Thirdly, the willingness to try again if their first attempt failed is also crucial in whether or not you are actually able to pass this right for the future and for everyone else who would need it. Now, why is this significantly more likely to happen and people are significantly more likely to access these sports on our side? Three reasons. First of all, they're more likely to start the process. Note, the people who generally suffer from not having rights are disadvantaged people, either people in poverty or racial minorities or people who are generally under the foot of society, not the ones stopping it. The reason why this is important is because they're more likely to not have the full financial power and the full power to just go through the entire legal process on their side of the house. The reason why that's the case is firstly, their willingness to accept the answer that is given to them, because the first answer when they seek legal advice is that it's just the way that the Constitution is. For someone that isn't highly educated or doesn't have a lot of time or money to spend in courts, this can usually be enough of an answer. On our side, their intrinsic moral response to and emotional response to, I think this is unjust and it's violating my right to justice, is more likely to permeate. Secondarily, I think they're more likely to retract it on their side of the house the moment that they face actual challenges within court. Because when they're being explained over and over again that this violates like the 5th or 7th or whatever amendment in the Constitution, it's harder for them to hold on to the thought that this society and the way that this is constructed can actually serve them well. The reason why this is important is because they can hang on to the idea that this should be just. And if they felt like something has been unjustly done to them, then they should keep going, they should keep pursuing this. Thus, regardless of all other arguments, people are more likely to seek justice and likely to obtain justice on OG.
Okay,
Yes, I consent. Okay. Starting in 3, 2, 1. Pano, I'm going to first respond to the reasons they gave as a response to us, then I'm going to do a Wayne because I heard you chisel over that. You like it very much and stuff. You give us high speaks. Irish people only. And then I'll do rebuttals anyways, because even if mitigate the risk and everything like this. Firstly, on their responses towards us, they say our case only kicks in when the courts are stacked, which is a limited number of times. Firstly, why is this not a limited number of times? Note that this is not exclusively America. The fundamental structure by which the court operates is that it is appointed by government, which means, especially in places like developing countries, where democracy is more vulnerable, where governments stay for longer, they have greater power to appoint courts that are more loyal to them. Stacking isn't an American word, it's just how it works and how it happens by default as the process continues. So in many places, the courts are stacked. They're loyal to the government or they have some political leaning. But secondly, note that judges will always have some political leaning and stuff like this. Fundamentally and stuff, they'll be raised in a certain way, brought up in a certain way, and the political beliefs will always exist. Here's something very crucial about founding fathers who make the constitutions. Their political beliefs don't matter because they have greater things to care about, like uniting the country when there is regime change and all of these things comparatively happening. So it's less likely that they are politicized, it's more likely the decisions will be politicized. Secondly though, this isn't only in cases where the courts are, how do you say, stacked and stuff like this. Let's say they're balanced. Even if they are, know that those judges are still capable of making wrong decisions and stuff like this. They're still capable to be affected by things happening currently. They never explain the incentives of these people. They prove that there may be progressive, and I'll explain this later, but why is the progressive decision even the good one and stuff like this? They never explain this sort of thing. We explain why constitutions are good, why constitutions apply to everyone and provide basic rights for everyone, because they must provide basic rights for everyone. So even if courts are not stacked, I don't understand why they need to differentiate themselves from the Constitution to provide this sort of basic rights. Secondly, they say it is easier to sell to the people when you're doing an undemocratic decision, when the Constitution exists, when you're simply using legal jargon, as opposed to when it's about whether this is wrong or right. Firstly, the discussion about whether this is wrong or right happens symmetrically, even on our side. Like it's not comparison solely with the bit about the Constitution. Also, secondly, not that the Constitution is not all that confusing to fucking interpret. Come on, it's usually written in simple language, purposefully, because I'll explain this in a second. How do you say? People need to understand. People needed to understand this sort of thing. There is room to interpret it, sure, but the most basic tenets of it will always be understood. On their side, comparatively, know that they always have the freedom to convince you that something is wrong or right. They governments often have massive media control and stuff like this. They can often rile people up with populist words and tell you, no, we need to limit the voting rights of these sorts of people right here. We need to remove them to create fear within the populace. Even if the discussion is about being wrong or right, people are always good at determining when it is wrong and when it is right. But we prove why the Constitution on aggregate is likely to be good, so we should win. Thirdly, they say elites control the creation of the government. Firstly, know that why is it likely not true? Constitutions are created when there is a change of power, right? This means that some elites lose power, other elites gain power. So this is the time when they need to establish their power chief of all. This is when they need to get their money. This is when they need to get their support. Also notice, this is when people are most democratically involved, because this is for the first time when they perceived voting. If they lived before in a dictatorship, or in a what do you call this thing, though, where Britain goes to Africa and stuff. Colonialism and everything. This is the first time they've been able to vote. This is most involved they're going to be. And over time it disappears. People stop caring about this. Governments retain over time, and they're able to corrupt processes of power that hold them accountable, or this sort of thing. But the Constitution stays. The Constitution does not change over time. It stays at the point where it's created in a most sort of thing. Now, what does this then mean? Firstly, and I want to flag one final thing. This is also about removing new rights, not just about extending new rights. They have no reason to say, oh, this is just about extending new rights and stuff like this. They just say it. It's obviously also about removing this sort of right and choosing who they apply to and everything like this. How you say legal precedent about this sort of particular things. Here is then the way. Sure, it's unfortunate, but we may not always get things like pro-gay policies in the Constitution, or personal stuff in the Constitution. How do you say? I don't remember. Right to privacy in the Constitution. But here is the very important piece of way. Our rights, the most basic rights, the rights to vote, the rights to have freedom from prosecution, all of these rights are maintained. Even if we don't always get the good things they talk about, it's comparatively much more important to not have the bad things we talk about. Why? For two particular reasons. Firstly, if the changes they talk about were all that good and everybody supported them, then these changes would happen anyways. Over time, we get in constitutional amendments that are pro-gay people, that are pro all of this sort of thing. But notice, when legal precedent happens anti-democracy on our side, it's very difficult to reverse this later on, both because the government can take power, but also because legal precedent matters substantially more. But also, secondly, before I go on closing,
gut check this. If a government has the power to overhaul the judiciary, corrupt democratic norms, and backslide the government into oblivion, they also have the capacity to stack the court and interpret them.
Don't have the capacity. No, this is what we're saying. Even if they're mega stacked, there is a limit on the status quo on how much they can diverge from the Constitution. Because the average person's conception of what is right and what is wrong is derived from the Constitution. On their side, all of the freedom of things like freedom of media, you can convince people of anything, the craziest shit you can think of, this sort of thing. On our side, there's always a limit. Like, okay, even if there isn't a massive like even if there isn't the biggest delta, and to some degree, how to say, they can still be able to use power. Know that this motion obviously is about changing something. It's obviously changing the degree to which they have control. So even if they don't totally have control, totally not have control, they probably have comparatively more control on their side. We explain why this is a bad thing. Second piece of way, those basic rights is comparatively far more important than gaining other rights. Why? Because basic rights are a prerequisite to accessing other rights, like freedom to marriage, like everything like this. If you're not able to vote or access basic economic things like school, all of these sort of particular things, then you don't have the liberty within your life to vote for laws that are good for you in order to access it, but also secondly, to fight for these things comparatively in the future, like pro-gay policies, like everything like this. And finally, no, judges are not progressive. Come on, like, do you fucking think in developing countries they're progressive and everything like this? The philosophy there is not progressive. These people are rich and elitist, this world schools analysis, but whatever, they're probably conservative, but even if they are, the constitution is good. Vote us.
Great.
Can people hear me if I talk like this?
Yeah.
Cool. Path runs parallel analysis of roughly equal quality contingent on the progressive or regressive composition of courts. From CG, we're going to prove why, regardless of whether or not courts are conservative or liberal, we widen the scope of access to recourse in the justice system for everyone in society, and that is firstly a moral and secondarily a political good. Before that, removing opening opposition from the round. First, on right-wing backlash. This is contextual and depends on the general degree of populism to society, but arguably, right-wing backlash would be far worse at the point at which these people who are backlashing believe that progressive courts are ruling against the Constitution, whereas if the Bill of Rights is broadly understood to be legally malleable, which is on our side because it doesn't exist and be interpreted in the broadest possible sense, it's probably likely to be less bad. If they're saying that backlash happens at the opt-in point when this policy is implemented, which I'm not sure they claim, but they might claim and CO may claim later, it's probably the case conservatives will whine about this for a few days, then go back to whining about trans people or whatever else they whine about in general. I'm not clear that this is going to be some salient sticking point in terms of conservative backlash. Then they say that over time, democratic backsliding happens and bad governments remove rights, blah, blah. Note that they're clearly still traumatized by their world's partial double octopinals because they thought this was relevant to the motion. But first, I'm not clear why changing the composition of rights that people have in a society is morally wrong inherently if they don't align with Western progressivism. Presumably, there could be a case where the court is more liberal than the general populace, and therefore the laws reflect the general preference of society. That could plausibly be good. No analysis as to why Western liberal progressivism is always good. But secondarily, and more importantly, if a government has the power to overhaul the judiciary, they also have the capacity to stack the court so broadly that they can interpret the Constitution in any way they so choose, or they can just abolish it entirely. Alex says they are very, very bad, like so bad that they can take away your rights on our side of the house through the system that allows them to do so, but also somehow simultaneously not bad enough that they can't stack the court enough to just misinterpret the Constitution and take away the rights of minorities that way. If this applies to a government, I posit it is an incredibly narrow edge case, so narrow that I cannot think of an example that properly fits it. The closest is probably Hungary, but even Hungary has, EU law and also legal precedent, which still exists on our side. Framing. What is the problem with bills of rights in the status quo, and why do they not reflect the preferences of the population today and the beliefs and rights they believe they are? Importantly, unlike opening government, we will not say it's because they were written by straight cis white men and therefore they are insufficiently woke, although that may be true. Rather, we will give structural reasons why bills of rights are outdated and bad. First, they were often written a long time ago, which means that the scope of rights enumerated at present that people consider important now, things like internet privacy, for example, or things like the right to be forgotten that could not have been conceptualized under the framers of the American Constitution, simply did not exist. Right. Therefore, that right is unlikely to be enumerated clearly if that right existed then, and if it did not exist then because they could not conceive of that right, it is likely not to be mentioned. Secondly, they tend to be limited very stringently to reinterpretation. That is to say that doctrines like constitutional originalism in the United States exist, which slow the ability to revise these things, but often very difficult to change over a long period of time, whether to get a 2/3 majority or legislative gridlock or one of these things. Thirdly, bills of rights are often very directly discriminatory. That is, they enumerate different rights for different groups of people. Insofar as that is true, it probably precludes a broad number of people from being able to access justice to a large extent. What this does is create the disjunct between the beliefs of popular rights and what the court actually claims as a right. So ideas like abortion, which are numbers in the Constitution according to liberal Supreme Courts and not enumerated at all, cannot be allowed to permanate. Now, opening government says something roughly equivalent to this when they say that the Supreme Courts are unlikely to be progressive. But note that what this does is it creates a disjunct between the rights enumerated constitutionally and the rights that people on the ground believe they should have, whether it's due to technological change or demographic shifts or any of these kind of things. Note this works both ways, right? It is just as plausible that a left-wing Supreme Court would engage in overreach that doesn't reflect the will of the people, as it is a right-wing but nonetheless democratic society. Why does this matter respond to OO? OO says that many constitutions are progressive. OG says constitutions are conservative. Arguably, both are true in different contexts. What we're saying is that regardless of whether or not the framers of the Constitution were super progressive for the time, they inevitably press shortcomings and create and perpetuate miscarriage of justice. First point, why do we get a justice system that gives people more access and consequently more leverage over the apparatus of the state? There are two tiers of analysis here, first principle, then practice. On the principle, note that the obligation of the justice system is to provide equal access to all people insofar as it exercises an absolute monopoly over their life. Insofar as that is true, we know that people have the maximum amount of recourse to influence the legal system. Therefore, we think the team that wins in this debate is the team that will usually give the people the maximum amount of leverage over the judicial system. We think that insofar as justice is malleable and arbitrary, you can't adjudicate whether progressivism or traditionalism is better, and plausibly different policies are better for different societies and reflective of the will of those people. We think that the metric on which we ought to adjudicate this debate is which said the justice system better reflects the will of the populace. Why then, on the practical level, do we get better outcomes? Importantly, this argument is true whether or not you believe progressivism in a judicial system is good or bad. Firstly, you widen the scope of access to the justice system dramatically. Why is there a limited scope of access in the status quo, even beyond what we've already said on Gov Bench? The first is that precedent serves as a means of deterrence. That is to say that when there's a large amount of legalese surrounding an issue, it tends to deter people from doing they want to seek justice in the first place. But the point at which it's less of a consideration, they're likely to bring more cases in the first place, or formulate challenges to existing statutes or law, and then come forward. But second, it's also necessary for states to explain what is precisely enumerated under the rights of justice. At the point at which it's the case that anyone can conceive of a right to justice challenge or something like this, as opposed to there being strict enumeration within the law, it becomes far more incumbent on courts and far more incumbent on lawyers to explain to citizens what precisely the scope and access of the challenge can possibly be. At that point, they're likely to internalize a greater degree of information about what kinds of challenges are possible, and therefore be better able to take advantage of the legal system, both in the immediate case that they're pursuing in this context, but also in the broader sense, because they have a better idea of what they're doing. Thirdly, there's likely to be many people who want to bring cases but cannot, because they're told they don't have a case by lawyers. Now they have the capacity to formulate an argument that otherwise would not exist. But fourthly, judges concerned about careers but are sympathetic to activist demands are less likely to rule in favor on their side, because they want to compromise the ability of to advance later on down the line, and they're worried about their ruling getting overturned by a later Supreme Court or compromising the reputation. Now at the point in which they have greater latitude for interpretation, it's plausibly more likely that people at the opt-in point to these kinds of things. But finally, structural discrimination. It's not just the woke thing of some places of repressive law. It also means that now you're able to adopt challenges to repressive statutes faster when actually with technological limitations or demographic shifts or things that framers of constitutions could not even be considered. You have significantly greater capacity to bring those challenges faster and update those laws and statutes far quicker than you on their side where you're always hostage to the status quo.
Okay, so the right to internet privacy, even if there isn't a constitutional protections for it, you can pass legislation as long as it's not prohibited by the Constitution. You can get most of your change through legislation.
The issue with legislation is that it's often subject to things like gridlock. It's often subject to things like the will of the people. It's often subject to a variety of different things like overturning. On our side of the house, at the point at which we give people leverage through courts, which again do set precedent under the right to justice, so it's not like it can just be overturned immediately or if like willy-nilly by the right of the people, like Alex says, we still do gain that degree of capacity on our side. The final claim I want to make is about more efficient. Note that Bill of Rights questions can often just waste a lot of time. You have to look at historical documents, definitional issues, things like this. You have to engage in all these kinds of things to a massive degree. This can often clog the court to a significant extent and set people back, not only in terms of addressing these constitutional challenges, but generally in terms of court capacity. On our side of the house, we get significantly less court clog and significantly more people being able to opt into the justice system on our side of the house at the point at which they engage in this. What is the weighing in this? Regardless of whether or not you believe progressive or conservative interpretations of the Constitution are more or less morally legitimate, we are the only team in the round that proves we give adequate leverage and rights-based protections for people faster. That is to say that we allow the government's laws to reflect the will of the people at a quicker rate and the preferences of that society in a democratic manner, regardless of whether or not you believe it based on a subjective moral interpretation on top of one side of the house is more morally legitimate or less morally legitimate than the other. From those.
Great, member of report.
If you have two eyes, I prefer not them non-verbally. The issue with this top half of this debate is that they talk too much about the process and not enough about outcomes. On closing opposition, we stand behind actually getting enforcement. I'm going to start out by responding to closing government and then do a few things. Firstly, frame why enforcement is the most important. Secondly, talk about why fewer cases get brought. And then thirdly, why buy-in to constitutions in the court is higher. Responses to closing government. I agree with most of Matt's speech, but just to think about reading in new rights like privacy. Firstly, we read the old constitution and we apply it to modern day issues. The right to privacy does not just exist for the telegraph, it can be applied to modern technology. Secondly, the fact that it's hard to change a constitution doesn't mean that it is impossible. If 2/3 of the population agree that a new right is essential, it is simply written in. Thirdly, as Harish says in the POI, we can just pass legislation. Gridlock is nonsense. It's just a check and balance. If the majority of people from both parties support something, gridlock is overcome. Maybe it takes a little bit longer, but eventually we do get legislative change. On the frame about why enforcement is the most important thing. The first thing to say here is that even if government gets slightly more progressive or better laws, that doesn't matter unless those laws are actually enforced, unless people actually bring cases, and unless there is buy-in. But secondly, this is also more important than the democratic backsliding stuff from our opening, because it applies in all cases. I disagree with Alec that the bad outweighs the good for the reason that Matt gives. In cases where democratic backsliding is a risk, governments can do extrajudicial things like threaten to imprison people, like sack the legislator as well, whereas the good things that we get are therefore more exclusive and comparative impact that are going to apply within all social contexts. How do we access our impact? First way that we do this is that more cases are going to be brought. Open opposition says the word there's more certainty, but we never see impact why certainty translates into positive things. We say that the essential nature of certainty is that more people end up bringing cases. I want to note that in order to bring a case, there's a huge degree of legal resources and of money. We need money to hire a lawyer, we need to take time off work, and there are massive degrees of emotional investment. Therefore, individuals are going to be substantially more inclined to bring cases when they actually can predict what the outcome of bringing that case is likely to be, i.e. rationally assess the fact that victory tends to be possible. The kind of preemptive response we get from Matt is, precedent is going to exist regardless. It will exist somewhat, but it is substantially weaker. This is for a few structural reasons. Firstly, the Constitution is not the supreme law of the land. Therefore, there's no legal obligation or any degree of obligation to actually follow that precedent. What if judges just disagree? What if judges just want to be activists? Who is now going to stop them? Judges can just ultimately think that they are justified in doing this, especially when it's about ambiguous moral questions about what justice actually means. So if judges want to be activists, there's very little checks and balances on that. Secondly, though, even if there's only minor precedent fluctuations, the precedent fluctuations that exist matter tremendously. Because it's literally about upending entire system of rights that exist. Even if in only like 2 or 3 cases judges can disagree, we're literally changing the entire constitutional bedrock of the state that's going to exist. No, open a government's case of we're going to get more progressive change over time literally relies on judges more radically changing precedent than change that would otherwise end up existing. Therefore, when certainty is something that's lower, it makes it harder to do a variety of things. It makes it harder to get a lawyer to agree to hear your legal arguments. Closing government says there's now a greater number of arguments that you can envision. A greater number of arguments that you can hypothesize does not matter unless you actually know that one of those arguments is going to get my case to result in a victory. Harder to form things like class action lawsuits are also necessary to amass legal resources and other people around you your case is ultimately going to fail. The individual is going to be deterred.
Naomi.
Even if you think that your case might succeed, there will also be the possibility of your case being overturned into the future when there's more fluctuation because precedent is less established are going to be higher as well. Meaning that we functionally flip the closing government principled way of we want individuals to control the system and individual protections and long-term enforcement of that is substantially higher. Before I talk about our second extension about buy-in, I'll take time off.
So while the process is tough for both sides, it's likely to be firstly tougher on your side to go when you have to fight legalistic battles, but secondarily, you mostly rely on the rationality of the individual, while we rely on the emotional process of feeling that something unjust has
I'm
happened.
sorry, the emotional process doesn't matter when you're literally gonna have to spend half of your income, half of your savings hiring a lawyer, right? Like, sure, you can feel empowered making arguments of justice. Your consideration is, will bringing this case create change for me? Will bringing this case create change for my community? And because it's such a big decision for myself, there is a rational process that ends up going into that, and you need to know if there is the ability for your argument to be heard rather than to just run a cool claim about justice. Secondly, why are buy-ins to constitutions and courts higher under our side of the house? So we think that under our side, people uniquely perceive constitutions and the decision-making of court as being more legitimate. This is for a couple of reasons. Firstly, there are tremendous degrees of nationalism that are built or in bills of rights and documents. This is for 2 reasons. Firstly, state propaganda that both teams on top of agree can theoretically exist. State propaganda machines make you swear on the Bill of Rights when you were in class. They convince you that these documents are good and ultimately be venerated. They are built into nationalism, so I'm proud to stand behind the Constitution of my country. But secondly, they tend to be affiliated with key national leaders as well. The Constitution of India is tied to leaders like Nehru, who individuals often respect. Given the way that founding fathers and all groups, not just in the American form, tend to be venerated, when your heroes are the ones who are writing constitutional documents, then you view the entirety of those documents with a higher degree of regard as well. The second reason though why constitutions are helpful in terms of increasing the degree of buy-in is that the subjective nature of right means that we need rights to be long-term in order to actually believe them. There is no code that was given to us by God. I mean, religions obviously disagree on this, which say X, Y, and Z is ultimately a right. Therefore, in order to convince people that rights are actually important, you need to convince them that they are inalienable. And the way that you convince people that rights are inalienable is when the same subset of rights have existed for a long period of time. If something has existed for longer, then you think it's more foundational to your country actually exist, as opposed to their side of the house, where rights fluctuate more. And even if they don't actually fluctuate more, the optics of where not codified rights that have existed for centuries exist is not actually the case. This is not about conservative backlash, as Matt tries to preempt. It is literally about every single citizen, regardless of where you stand on the political spectrum, believing that my nation has a certain subset of rights, and those rights are ultimately essential. Why is this then the most important thing? When you undermine the court, it makes all decisions that the court reaches substantially less efficacious. These are cases involving human rights law, but there are also all other cases as well. In order for the case to have any effect, what you need are grassroots support and compliance partners on the ground who are going to help you enforce those cases. Roe versus Wade was slowly chipped away because conservatives disagreed with the verdict. Think about Brown versus Ford, and after that it took years to actually successfully be able to desegregate schools. Compliance partners are necessary for two reasons. Firstly, it's implausible that every single rights violation is going to be successfully challenged within court. Therefore, we need our more institutionalization. We cannot sue every school for still upholding desegregation. What we need is people on the ground believing that the hard rights reached by courts ought to translate into software that support people on the ground. And secondly, otherwise there can be traditional forms of backlash. It is often useless to extend one right to a group, as that is going to lead to three other rights being violated because people think that the courts are ultimately nonsense. Therefore, it is necessary to uphold regard for the court overall by consistency. Extremely proud to say in opposing opposition.
Great, so that's.
Are you ready? Three, two. Justice is a confusing concept. The clearest answer you can get is one in which the majority of society agrees, the majority of society has deliberate discussion about, and where the majority of society is able to access those discussions and access what it means to be just. We believe the dead have no rights, nor do the particles that consume the earth in which they sleep in. I'm going to take out CG, then I'm going to weigh against OG and take out, no, sorry, weigh against CO, then OG, then I'll have the order mixed up. Great, so on CGs. First, note the response to us and why they're quite flippant. The first thing they say is that these can be applied because they're broad concepts. But note this is just on face intuitively untrue. That is to say, maybe they could have seen the telegraph and that like the internet can be similar to a telegraph. But you cannot conceive of things like, for example, the metaverse, or things like, for example, what is a transgender bathroom? Or for example, what does it mean to be non-binary? That is to say, structurally and intuitively, people in the current age cannot foresee things that can happen in hundreds or thousands of years. So at best, they probably won't win on that. Secondarily, they say gridlock doesn't really exist. If it's super progressive, 2/3 of the populace can just agree on it. Note that like most of the populace can agree on basic rights, but they cannot agree to form a procedure in order to achieve those rights. That is to say, it's gridlock based on politicization, the fact that it can be filibustered or the equivalent to filibusters in other places, or by wasting the time and distracting the populace from other issues. So they might agree that something ought to be changed, but they don't have the structural capacity to because it is hindered by the systems that exist that hinder collaboration that Matt told you about. Let's dismantle the CG case now. The crux of their case is that more cases will likely be brought up, trying to kind of flip our case, because there's certainty. You can otherwise predict the outcome. I'm going to dismantle this in a number of ways. Firstly, I think you comparatively have more capacity on our side because you are not otherwise deterred by precedents. So think of the structure of cases that they are likely to be brought up. They are likely to bring up cases that are certain, that you know what the outcome will be. If you know what the outcome will be, you won't bring up a case because you know what the fucking outcome will be. So in other words,
uncertainty is the access point by which people bring up more cases because they never otherwise could have conceived they could get an adjudication. They felt limited and shackled by precedents that they never otherwise agreed with. Secondarily, for the people that otherwise need the funding or the capacity to access this is where activist groups come in that give the startup capital or the initiation points to bring up a case in the first place. So even if, for example, a lawyer might think, I don't want to bring up this case because I'm unsure, an activist group provides the funding because they're like, at least there's an attempt now, so we will give you the money. Thirdly, people understand the legal system comparatively better and can argue for why lawyers ought to take up their cases and construct meaningful arguments for why it can be changed. So it looks like news outlets, it looks like opinionated editorials, blogs, the participation of society. But fourthly, note, and this is critical, it opens standing. It opens grievances that could otherwise never be accessed. So even if we take them at their best, that it is a certain portion of cases, the impact on accessibility is quite marginal insofar as people would have predicted the outcome anyway. But the comparative pie on our side is standing that never otherwise exists. So even if they're winning on one clash, the point is we give you a new set or a new bucket that could otherwise tip over and has a higher marginal value than the ones that they give. Finally, note on backlash. This is a bit silly insofar as I think this is unlikely to materialize insofar as one, the 24-hour news cycle exists. In other words, so people otherwise aren't uncertain of like what happens within the judicial system or understand it. It's very likely that insofar as private business interest groups also have interest in other things that want to fund it, they're probably going to be distracted by other things. But secondarily, note, I think it's likely the government will message smartly about it because they don't want unrest, and this is critical. If both parties see the opportunity to capitalize on it, they will tell their constituent that you should buy into it. So even if the worst pernicious incentives exist that OO tell us about, that mitigates the impact that CO are trying to get at. But fourthly, note, these rights don't go away and they will be communicated to them. That is to say, we're not going to take away your right, for example, to have free speech. It's probably likely that people say there are conceptions of justice that everybody agrees on. So in other words, and this is why I'm going to engage with OO a lot now. OO say, so OO say that the reason constitutions are better is because there's a starting point that is high. That is to say, it's a new government, it's made with the euphoria of creating a new democracy, everybody's on the same side. So these rights will like us, otherwise the constitution will be better than a malleable conception of justice. But note, if that's true, the precedents underlying those will also be based on euphoric precedents that everybody agreed on. But secondarily, note, everybody agrees on these conceptions of justice. That is to say, the difference or the delta is not based on like the wording that a constitution provides, but rather like it's not based on like the wording that a constitution otherwise provides, but the inherent capacity to change. That is to say, note that people agree what basic rights should be. The reason that it is malleable or changed or essentially corrupted is because people misinterpret whether a policy actually aligns with that basic right. So everyone agrees, for example, corruption is something that otherwise shouldn't exist. Or the fact that people should have some sort of right to privacy. The question is whether it's corrupted by pernicious interests like the conservative courts to say this does or does not violate it based on the interpretation. So it's not the wording, because the wording also exists on our side. But secondarily, note, where was it? These are basic rights. Thirdly, note it's still symmetric insofar as the Bill of Rights still allows for the worst natures of these stack judges, insofar as conflicting interpretations can otherwise exist. Now let's get into the flexibility part. But before engaging with that, I'll take a look.
Okay, obviously legal precedent at the start is much easier to ignore and to not pay attention to than the Constitution. Obviously, it's not the same as if you had a Constitution written at the start that carries out everything. So this response does not work, which you nodded to.
No, the legal precedent still exists in our side insofar as one, judges have career objectives where they don't want to be seen as outcast or the black sheep violating 30 years of precedent without actually giving a proper justification for it. Secondarily, if society believes in the conceptions and laws that were otherwise written within these constitutions, that means the laws also reflected and people have an understanding of what is a common principle within that society, which is what the laws are otherwise based off of. So the precedent POI doesn't land. Now, if there's a clash on flexibility versus not, the question that you have to adjudicate on top of is what is the optimal point of flexibility? That is to say, the Bill of Rights or Constitution shouldn't be entirely like flexible and changeable because we should have some consistency, but they also shouldn't be so rigid that they can't otherwise be changed. What Matt tells you is that we reach a proper optimal point. That is to say, OG tell you Why, for example, you might not be able to have the telegraph, for example, or like the telegraph might not reflect things like, for example, the internet. But the issue with this, is that it's not explained for why it's structural or the environment that laws are otherwise written in. In other words, what you have to adjudicate is why these constitutions don't have the capacity to otherwise, not why they might be regressive or not. Math mechanisms are far more structural, but I think I'm clearly wondering.
It does not matter what cases are brought to the Supreme Court or any court if the rights which were then given are not going to be enforced. And the moral minimums, which probably both sides exist in both cases, aren't going to be supported. That is the problem, or one of them, with closing government. Even their best case, which is wrong, you would nonetheless maybe get a few more cases brought forward, but uncertainty means both would fail and you prevent enforcement of many of the rights which actually matter to people, because when we tell you an extension and they give you next to no response to. Let me first deal with one issue from closing government, because they want to claim that what the court should do is reflect the will of the population. Let's assume that isn't a very controversial premise. Bearing in mind, even though the government seems to care a great deal about minority rights, it isn't obvious that it was what the population or what a specific period in time. Even to the degree that is true, here is the comparative. They claim that their case doesn't depend on what the court looks like. Nonsense. Their case entirely depends on the court actually focusing on what reflecting popular will. Why would that plausibly be true? No reason from their side of the house. Just note, it depends on political actors who may not even represent the majority will when able to pass. For instance, people with presidency without a majority vote, and the Senate without a majority of the popular vote. You could be elected for a long period of time. So what changes is in something which you actually reflect. It isn't obvious at all that the court is reflective of popular will, which is the premise of their case. But let's just do the comparative here, which they partially responded to. Here's the thing. If there is an issue which needs to be modernized, you can still pass legislation. So removing Roe v. Wade hasn't removed abortion. It just means you don't have a right to abortion. The fact that you might not have a right to privacy doesn't prevent a legislature from changing them. Why is that important? Because you still have a mechanism for popular will. There is one response to that side, which is you can have practical difficulties because of gridlock. Several responses to this. One, I am not sure this is necessarily bad, because what that requires is you need more than a straightforward majority, maybe in some cases. Depends on the countries. That seems to rely very heavily on the United States. I think it's a practical protection to ensure that you probably have reasonable support. Secondly, I don't think it is bad that you will have parties often frustrated within Parliament. Parties want to be able to do something, to show that they have actual achievements. And as a result, they are willing to pass policies, particularly if they're relatively well supported amongst the population. Finally, even to the degree that they are not, and you're one party which is constantly opposing the other party, that's when horse trading comes to place. I will support this piece of legislation, you support that piece of legislation. Therefore, even in a system where you get gridlock, you will still often end up with some level of change. Why does all of this matter? Because the legislative approach is clearly one which better reflects the popular will than the uncertainty involved in the judges they are talking about, who aren't even necessarily be reflective of the popular will. That is the problem with their case. Let's talk then about enforcement, because that side of the House always will talk about what these rights would be. I think that is important. I'll talk about that one in a moment. But at least as important, considerably more important, is can you enforce the rights which you are going to be given? Because that's what matters to people on the ground. Not what is written on a piece of paper, that does a state, local, or federal, does an authority actually live up to the rights which you are given? Why is that considerably less likely on their side of the House? A couple of reasons. Firstly, we talk about the veneration of the Bill of Rights as given right now. Historical, as Naomi tells you. It's the way people look at the founding fathers, because people see these rights obviously sacrosanct. I've not repeated all of that analysis, but was all there not responded to. Why does that matter? Because the Bill of Rights and constitutions do not enforce themselves. The enforcement of these laws requires action on the part of the state. You need a state or a government which has executive power to ensure that other states enforce it, to ensure local authorities enforce it, to ensure funding it makes these things actually take place. That's the point, for instance, of Roe v. Wade or private support of education. Sure, that is an issue on our side. It becomes considerably worse on their side of the House as a result of this policy that is less likely to have popular will and popular support for the Constitution. So even in their best case, where these things are actually passed, enforcement office becomes considerably less certain to take the most important controversial issues. That matters for open government. We want to talk about things like transgender rights. Those are least likely to be enforced, but people do not support the Constitution, or at least don't get the same precedents and unprecedented support it actually does. That deals with parts of open government, and indeed, it's prior to everything we get from closing government. Secondly, though, do you actually get cases brought forward? But before that, I'll take open government.
Population buy-in can be prevented by bad or corrupt judges, media communication, or bureaucratic staff that prevent implementation. People or lawyers attempting is more certain CG can strawman us and claim it as their argument.
Fair enough, but now people that argument. Okay, so now let's talk about what cases are being brought forward to the court. Because this seems to be part of the clash on the back half or the now important issue, which is why is it less likely you are able to claim your rights in the first place? And what CG and I guess OG effectively could claim about is uncertainty. That uncertainty means you're more likely to bring a case. But look, there's clearly a spectrum here between things which are highly uncertain, where you have next to no idea what's going to happen, and some degree of probability that you think will get things your way. It is unlikely that private funders will fund things where there's almost a huge amount of uncertainty, but they may find something which you think is 50–75% likely to take place. That is also true about activist groups, for instance. Irrespective of the fact they're not often that large or don't have that much money, they have to prioritize certain cases and then move forward certain cases, certain causes. Do they even put money towards a court case rather than another kind of way of getting things passed at all? They will make that decision for what they think will make the most returns and actually help that cause going forward. Why is that more likely than in the House? First, they have something they actually go to look to. Now, closing government is probably right that normal people will struggle to make these arguments about the Supreme Court because they obviously don't. You will still get lawyers on the either side of the House who will be making these actual arguments. So I don't think that's necessarily true. But more importantly, even if that's all true, you believe that all untrue, you believe all of that is symmetric. Why are you trying to turn to the courts when you know in 4, 5, 10 years, it is very easy to undermine that by simply going to the court again and saying, well, you no longer believe in that natural right. Why does this then matter? It partly matters, it's a large part of closing government's case, but it also matters because what the argument is effectively doing is saying people can't go before the court and are less likely to go before the court. These minority groups are less likely to go before the court. It's that uncertainty means the court pathway is a bad one, and this means you will not get the funding necessary to go through all that. At the end of this debate, you do not get enforcement of these laws, you do not get the laws you want, and there are better ways of reflecting popular will, even if that's your goal. We're very happy to announce.
Great, and go ahead, like, we'll have an way for you in the